You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app. Or listen on demand wherever you get your podcasts.
Welcome to the Bloomberg Law Show. I'm Lydia Wheeler.
And I'm Greg Stohr. We're in for June Grasso, who's out this week. Ahead in this hour, we'll talk about the legal fight over whether former President Donald Trump is prohibited under the Constitution from holding office again because of the role he played in the January 6th attack on the Capitol.
All that to come. But first, we're going to talk about clean beauty products.
You know, we all try to become more conscious of the things we're putting in our body. It's not just limited to food, but also includes your beauty products.
Yes. Your skin is your biggest organ.
Yep.
Oh, yeah. Well, think about it now, too. Like, even with something like sunscreen, like, well, we do these micro zincs. Well, zinc isn't terrible for you, but, you know, you can do all these different other things that are non-nano to where they don't go into your bloodstream. There's just so much that needs to be learned.
That was a clip from Daytime Chicago. The news show did a segment on the best clean beauty products like eye creams, cleansers, and moisturizers. Some big retailers have now found themselves entangled in litigation over these very products. Joining us now to talk about the litigation is Heather Bustos, a Food and Drug Administration compliance attorney and managing partner of Bustos Law Group. Heather, thanks for joining us. Can you tell us what retailers are being sued over and why?
Sure. So thank you so much for having me. So right now, Target and Sephora are actually facing lawsuits. And really the issue is that they are essentially claiming that the products that they're selling are considered clean. And these lawsuits are stating that consumers do not really agree with the definition of clean that Sephora and Target have. And so this is one of many. These are a couple of many lawsuits that are now in the wings and probably will continue moving forward.
Heather, for those of us who think of clean beauty as making sure there's a bar of soap in the shower, can you just sort of define a little bit what we're talking about? Are we talking about products that, you know, don't have things that harm the person using it? Are we talking about products that are environmentally sensitive or both?
I think there's a little bit of both. There are ranges of definitions amongst different companies, and that's why there's so much confusion around the term. But most people tend to think it means free from harmful chemicals. In some cases, harmful is also an issue where it can be, you know, something that's cancer causing, and people have difficulty even defining what's considered harmful. And so that's why this litigation is happening, because essentially the definition is not really clear.
Can you walk us back, give us a little history here? When did this trend begin and how did it start?
That's a great question. So clean beauty kind of began as really with makeup in the 1970s, and then it moved into the clean eating movement during the 1990s in California. And since then, obviously, we've seen a rise. It's really popular with Gen Z and millennials. And so this has become like a really strong marketing term, and it allows companies to really succeed in the market utilizing clean, you know, in their marketing.
Are there any regulations out there, the Food and Drug Administration, the Federal Trade Commission, the states, anybody who has tried to define what clean means?
So the FTC does have some green guides, what they call green guides, that go into some vague definitions, but not specific to the term clean. That's why these lawsuits have been able to move forward, is because there's not a lot of, you know, clarity on what the meaning is.
What about regulations for advertisers? Aren't there rules about deceptive or unfair advertising practices? And would this even fall into that? Like, is this considered deceptive to call something clean if we don't really know how to define clean?
Right, and that is the big question, and that is what the courts will have to kind of come up with, you know, the answer to that, because essentially you're looking at a consumer's perspective. That's what the FDA uses. The FTC, they look at, what a layperson would look at that product and essentially think clean means. And so they will have to come up with that definition.
Tell us a little more about these lawsuits that are out there against folks like Target and Sephora. Who's behind them? What are they claiming? What are they asking for?
currently, there are quite a few plaintiffs' attorneys that are bringing consumer lawsuits, and this is not just in the cosmetic space. This is happening in the food space, the supplement space, and essentially it's going back to deceptive practices, and they're claiming that companies are being deceptive in their marketing, and they're using terms that would deceive the customer into purchasing it. And so that's where a lot of these issues are coming from.
What are the retailers here, Sephora and Target, saying in response to this litigation?
In the lawsuits themselves, essentially they're stating that they haven't made any environmental claims. So I think at this point they're trying to claim that, number one, that the definitions are not solid, and number two, that they're not actually being deceptive. And so it's really going to come down to a lot of evidence about what consumers believe these terms mean.
Why is this litigation happening now? If clean beauty products have been around for decades, why all of a sudden now is there are these allegations that companies are mismarketing things?
I think we're seeing a trend, and you're seeing this, for example, in California, where they're coming out and banning ingredients. You're seeing consumers become more educated on what's in their product, and a lot of it is, I think, social media. There's a lot of education out there for consumers now. You have different apps like Yuka or websites like the EWG, which are giving consumers more education. And so that's allowing them to know a little bit more about what should or shouldn't be in their products. But yeah, we're generally seeing that trend rise.
So you mentioned education. So what should consumers know about clean beauty products?
I think that consumers need to definitely look deeper than just the term clean and look at the ingredients themselves. Unfortunately, in the U.S., there are likely, I don't want to overgeneralize that companies think this per se, but if you were to look at just regulations from, on the FDA side and look at what ingredients are banned, there's only 11 banned ingredients by the FDA for cosmetics. And so a lot of companies may believe that, well, if the ingredients are not banned, then they can be used. And so that's really the issue that I see there. Sure.
Heather, can you talk just a little bit about the industry and the market? How big is it? How many companies are there out there marketing clean beauty products, and who is the target audience? So
the market is massive. I remember looking and it said it's expected that by 2027 it'll be $11.6 billion, the clean beauty market. So it's massive, and that's why there's a lot of benefit to marketing your product as clean. And so a lot of companies are having to make this decision between being competitive and trying to avoid risk in the case of the litigation that's coming forward.
I mentioned earlier in the segment about, that clip they were talking about moisturizers and lotions and eye creams and that kind of thing. But when you're talking about beauty products, like what does this encompass? Are we talking about everything, including makeup and stuff? Can you talk a little bit about the types of products that you've seen?
Beauty products, at least in terms of the definition by FDA, it's anything that's applied to the outside of the body for beautification purposes. And so it's, like you said, it can be a very wide range of products. Really, cosmetics can be anything from lotions to some, hair products like shampoos. It can also include nail products. So there's a very wide range when it comes to what's considered a cosmetic. Even perfumes are considered cosmetics as well.
Coming up on the program, we'll get more on the litigation over clean beauty products with attorney Heather Bustos. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast on Apple, Spotify, or wherever you get your podcasts. I'm Greg Stohr.
And I'm Lydia Wheeler. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch the program weekdays at 10 p.m. Eastern on Bloomberg Radio, the TuneIn app, Bloomberg.com, and the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
I'm Greg Stohr.
And I'm Lydia Wheeler. We're in for June Grasso. We've been speaking with Heather Bustos, an FDA compliance attorney and partner at Bustos Law Group, about litigation over clean beauty products. So, Heather, what do you see happening with these lawsuits against Sephora and Target?
It's really hard to say what the outcome will be. I believe there have been some lawsuits recently. There was one against L'Oreal that was thrown out because I believe that in that case, there was no real harm shown to consumers, and that's always an issue that comes up in some of these class action type lawsuits that come forward. So it's hard to say what will happen, but hopefully we'll get some idea as to what the courts deem is at least a shell of a definition. We're hoping that will be the case. And in the meantime, there are agencies or organizations like the Independent Beauty Association trying to push agencies like the FDA and FTC to give a definition in the meantime. So we're trying to see who will win in that case of providing a clear definition.
Are these sorts of legal fights new, or has there been similar litigation over other product claims in the past?
These are definitely not new. There are many issues across the board. So in cosmetics, this is something that I believe is maybe newer on the cosmetic side, but especially on the food side, there have been many lawsuits around the terms natural, for example, and that also comes in on the beauty side. And in those two cases, in different product categories, there's going to be different definitions. So this is definitely not new, and I think the trend is just going up and up. And with my own clients, I'm having these conversations on a daily basis where it used to be, maybe not as much of an issue. It's definitely coming to the forefront, and I'm thinking about it as the products are being developed.
So, Heather, you mentioned your clients, and this is something that you're giving counsel on. What exactly are you telling them then?
So what we're trying to do is balance the risk of a lawsuit with their competitive edge in the market. And every client's going to be a little different in terms of how they see risk. And so I'm definitely bringing up a lot of the claims that are at issue in litigation currently and what I'm expecting to be in litigation, and allowing clients to make those decisions, but definitely trying to steer them towards taking as little risk as possible. The issue here that I see is companies are not really immune. I don't think there's any company that's immune because of the fact that we don't have clear definitions. So ultimately, if that term is allowing companies to market and, be successful, then they really don't have a huge amount of choice in whether they use it or not. And so something that I've provided guidance on is using asterisks and providing their own definitions so that consumers are at least on notice of what their definition of clean means.
So you co-authored a legal insight for Bloomberg Law, and that article touched on equity issues involved in the marketing of these products. Can you just tell us a little bit about that?
So in terms of equity, there are issues with natural ingredients used in beauty products not being attributed to people of color and essentially where those ingredients came from. And so in terms of marketing, it's almost erasing some of the origins of these ingredients.
You mentioned before about counseling your clients about how to avoid this litigation. You mentioned that some of them are defining what clean is on their own. How else can they protect themselves? Are some clients just saying, okay, I'm not going to market this as clean? And if so, is that them not being competitive? I mean, what are they doing here, to try to avoid that risk?
Yeah, I think with different clients, it's turned out differently. Some of them are willing to take on the risk of using the term and just providing the definition. Others have just completely removed it from their marketing and kind of focused on educating on the ingredients they do use and the ingredients that they're keeping out. so instead of using an overarching term of clean, they're just providing the definition by showcasing the ingredients they're using or keeping out of the product.
Ask you to look into the future a little bit. What impact would you imagine this litigation might have on the industry?
Well, it's definitely going to cause a lot of companies to be more aware of the claims that they're placing on their products. It's going to cause them to be probably more conservative than they would have been in the past. And this is something we're seeing even, within the FTC regulations and what they're coming out with. They've issued a few new guidances in the past, I'd say 6 months or so, up to a year. And these guidances are causing, people to be more aware of, or companies rather, to be more aware of the types of claims they're using. And so I think it's all leading up to the same result, which is companies being more cautious with the types of claims that they're using on their products.
Can you talk a little bit more about that new guidance from the FTC? What exactly are they saying?
So there is one of the new guidances that was released is the Health Products Compliance Guidance, which has now, it really focuses more on the substantiation side, but it's provided a lot of guidance to companies as to what kinds of claims require what levels of substantiation. And so, like I said, it's ultimately the more guidance industry has, the more able they are to be within the bounds of what's expected. And so when these guidances come out, number one, they're much easier to read than to read through legal, through opinions from court cases. And so it allows companies to be more educated on what they can or can't do.
Heather, we're talking about clean beauty products, but is there anything else that's popped up in the marketplace that's similar to this, like when we're thinking about beauty products, that you think could be the next thing that causes there to be litigation, some other marketing tool or scheme?
Currently, the terms that we're looking at, obviously clean, the term natural has been a source of confusion, and there's been a lack of clarity on that as well. And the term green, which I think goes across product categories. It's not just in the cosmetic space. It goes into, like I said, into the food space and even into consumer products, like cleaning products where they're using natural and green. So I definitely think in the future, these are going to continue to be a source of contention.
Our thanks to Heather Bustos, an FDA compliance attorney and managing partner at Bustos Law Group. Coming up next on the Bloomberg Law Show, we'll dive into the constitutional fight over whether former President Donald Trump can hold office again. I'm Greg Stohr.
And I'm Lydia Wheeler. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app, or listen on demand wherever you get your podcasts.
I'm Lydia Wheeler.
And I'm Greg Stohr. We're in for June Grasso. The Colorado Supreme Court last week considered whether Donald Trump is prohibited under the Constitution's insurrection clause from becoming president again after the January 6 attack on the Capitol. Here's Colorado Supreme Court Justice William W. Hood III.
As to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function? In some ways, that seems like a poster child for insurrection.
It's one of several cases that seek to keep Trump off the 2024 presidential ballot and ultimately could land at the Supreme Court. Joining us to discuss it all is Bloomberg News reporter Zoe Tillman, who covers the intersection of law and politics, and especially law and Donald Trump these days. Zoe, thanks for joining us. Let's start with the constitutional basics. What is the insurrection clause?
Going back to the post-Civil War period, the Reconstruction era, U.S. government was looking for ways to make sure that high-level officials, or really a number of people who had supported secession and, the Confederacy, were barred from participating in government, at least for the time being. So in 1868, they ratified Section 3, which is the language that we're all dealing with now, the 14th Amendment, which basically says, if you took an oath under the Constitution to support the Constitution and held an office, what office exactly is a matter of contention. But if you did that and then you engaged in insurrection or rebellion against the Constitution, you were barred from holding other office under the United States going forward. It's language that was very relevant at the time it was ratified and used and invoked, but then was mostly dormant for a lot of American history after that point. It really didn't come up. There weren't many rebellions or insurrections that we had to contend with. And then it suddenly roared back to life after the attack on the Capitol on January 6th, where, a lot of scholars said, hey, this language is still there, and just because it hasn't been used doesn't mean it's not still operative. It doesn't say, only applies to the Civil War of the 19th century. It just says insurrection, and it really revived a debate about whether it could apply to folks who participated in January 6th, and then sort of more relevant to our discussion today, whether it could apply to people like Donald Trump, who didn't physically storm the Capitol, but were sort of at the heart of what happened on January 6th.
So can you give us an overview of the biggest cases out there involving Trump and the insurrection clause? Who exactly is pressing, this issue, and where are these cases?
So there are a lot of them. There are more than 36 that we've found so far that have been filed in courts across the country. The vast majority have been dismissed really early on and, are not considered sort of the major challenges. A lot of them have been brought by a sort of minor GOP presidential candidate who's been, filing suit in federal court and claiming, because he's registered to run in the primary against Donald Trump, he has sort of a competitor standing to sue over Trump's eligibility. But courts have largely been saying doesn't give us jurisdiction here, and those have been tossed out. Now, there are 4 cases at this point that everyone is watching for a number of reasons. They're all in state court, which is important because, what we're really dealing with is state election law and what each state has to say about how election officials decide who gets on the ballot, the timeline for that, the process. So the 4 cases have been in Colorado, Michigan, Minnesota, and most recently Oregon. The case in Colorado, which has really gotten the most attention and has moved along as farther in the process, was brought by a group called Citizens for Responsibility and Ethics in Washington, or CREW, and that's important because they actually won, so far, the only case to prevail in getting someone removed from office under Section 3, and that was a county commissioner in New Mexico who was convicted of a crime for being part of the Capitol attack, and they successfully went to court to get him removed from office. So they're now bringing this case in Colorado that was just argued in the state Supreme Court. And then another group called Free Speech for People. They've brought the other 3 cases, or they're one of several groups and law firms involved in Michigan, Oregon, and Minnesota.
One thing I didn't hear you mention in there is the idea of a state trying to keep Donald Trump off the ballot. One might have thought that, say, a state secretary of state who's in charge of the elections might have said, no, I'm not going to put him, or I'm going to try to keep him off the ballot because he engaged in insurrection. Has that not happened?
It has not. And even secretaries of state who are Democrats, who are opposed to Trump, have been really wary to be the ones to take the leap first. And we've seen a number of these officials say, this is extremely untested, uncharted waters for all of us. And I would much rather have a court be the one that sort of punted it over to the judiciary and said, we'd much rather have a judge or our state Supreme Court or the U.S. Supreme Court make an official determination on these legal questions before I, a humble state servant, go so far as to tell, a candidate, major candidate, probably the front runner for the GOP nomination, that he can't appear on the ballot. So they're in court as defendants in these cases because they are the actors that a court would order to do something, whether it's to keep someone off a ballot or take additional steps to deal with these challenges, but they are not sort of actively litigating for one side or the other. They're basically saying, whatever judge you decide, we will follow your ruling. Some have supported the challengers insofar as, arguing that January 6th was an insurrection and kind of getting behind that theory, but not wanting to be the ones to say, yes or no, he is eligible or not to appear on ballots.
So what exactly is this argument? What's the basic argument that those seeking to keep Trump off the ballot are making?
First and foremost, that January 6th was an insurrection, and that's not necessarily a given. The word insurrection isn't clearly defined in the Constitution, so it's sort of potentially open for debate what an insurrection is, and that was something that the Colorado Supreme Court went back and forth with the lawyers about. At one point it was Donald Trump's lawyer was saying, there weren't enough firearms that it could be an insurrection because they didn't have the weaponry to actually overthrow Congress. And then the justices, it was sort of this extraordinary back and forth where they were saying, they had makeshift weapons that they could use, and there was certainly a lot of violence. So where's the line for how much, violence there has to be or how much weaponry there has to be for something to be an insurrection? But the challengers are saying, yes, what they wanted was to overthrow lawfully elected government and governance at the time, and that is an insurrection. So that's one of the main arguments. And then the next question is, did Donald Trump engage in that insurrection? And the challengers are saying, yes, that he was the driving force in, directing his supporters that day to go to the Capitol. And before that, really inciting them and motivating them by saying the election was stolen and it's up to you to, go to your state lawmakers and go to Congress to stop this stolen election. And then the sort of big picture, our overarching constitutional question and issue that the challengers are arguing is that Section 3, does apply to a president or a former president who is seeking the presidency again. And that has been, actually one of the primary issues in contention here, because Section 3 is, and everyone agrees, silent on this issue. It lists other offices, it mentions senators, representatives, federal electors, but it doesn't say president or vice president. And what they're saying is there's a catch-all reference to officers, federal officers, office under the United States. And the question is, was that meant to capture everything that's not listed, including and up to the presidency?
Zoe, how have these cases been faring so far?
As of now, Donald Trump has been winning in the sense that no one has succeeded in stopping him from appearing on a ballot, especially heading into the primary season when, states are literally getting ready in the next few weeks to print their ballots and get ready for primary contests. He is appealing, however, in Colorado, the judge's determination that it was an insurrection on January 6th and that he engaged in it. Where he won that case was the judge said, however, I don't find that Section 3 applies to a former president seeking office again. So it was, a win in that he stays on the ballot, but they would prefer there not to be official court ruling out there that he engaged in insurrection. So they are fighting that. But for the most part, he's won, and for different reasons. In Michigan, the judge there said that this was a political question, that the courts simply shouldn't decide. And there's some disagreement among judges on that question. So that issue is up on appeal. In Minnesota, the state Supreme Court said basically that the primary contest wasn't really an area where a state election official had power to keep someone off the ballot. So it was sort of moot and not really ripe at this point. And the question of the general election, it was just too early to decide any of the issues. So they sort of said the primary, we don't really have jurisdiction to deal with this. It's just for states to help the parties decide who their nominees are going to be. And maybe we bring this back for the general election.
So does this ever become a case for the United States Supreme Court? And if so, when does that happen?
I think that all of the state judges are hoping it does, and that no one seems to want to be the final word on this issue. A number of the state judges have expressed concern, that if one state does something that conflicts with what another state does, that this causes, a mass national constitutional crisis. And there's been several exchanges where lawyers and judges have said, and hopefully, if it becomes really a problem, the U.S. Supreme Court will just step in and resolve all of this. Whatever the state Supreme Courts do can be then taken to the justices, and they don't, obviously have to take it. But deciding not to take a case is, of course, action in and of itself. And if Donald Trump continues to win in these cases and the challengers petition the justices to intervene and they say no, it really does end the fight. There isn't much more they can do at that point. So we're really waiting for these state Supreme Courts to take enough action and then see if the challengers decide that they want to take that next step of bringing it to the justices.
Zoe, is there an argument that the Supreme Court should decide this at the first available opportunity? Because it isn't the case that certainty is better for everybody to get it sooner rather than later?
Yeah, one of the Colorado Supreme Court justices made that point and asked, what is the point in waiting and potentially opening the door to far more chaos if the electoral process gets farther along? Why not just resolve all of these issues now? And there are overarching legal questions that Trump and his campaign are saying, these cases don't even belong in court. So no one should get to the question of its applicability to Donald Trump, and no one should be deciding anything about January 6th because they don't belong in court at all. So they're arguing that this needs to just end now. But other folks are making the case that it's out there, and perhaps it would be better to get some clarity before Americans head to the polls.
Undoubtedly a topic we will be talking about again and perhaps frequently. That was Bloomberg News reporter Zoe Tillman. Zoe, thanks so much for joining us. That's going to do it for this edition of the Bloomberg Law Show. I'm Greg Stohr.
And I'm Lydia Wheeler. Stay with us. Top stories and global business headlines are coming up right now.